Welcome to Time to Get Your blah, blah, blah together. We'll be discussing everything from estate planning to how to avoid probate administration, everything in between. So let me introduce to you Samantha Fitzgerald. Samantha is an attorney in plantation, and her firm is 100% focused on estate planning and probate and trust administration. She has been practicing for over 20 years. Hard to believe. She's so amazing. She is a CPA and has her LLM in tax. And I'm your host and moderator, Bianca Moreras. I've been business development and career transition coach and consultant for over 36 years. And I bring a lot of information to the table, and I concentrate with attorneys. So without further ado, let's start our presentation today, which is focusing on probate. All right. So Sam, good afternoon. How are you today?
Very good. Thank you, Bianca, for the introduction.
That's great. Well, let's start at the beginning. What is probate?
So probate is a court proceeding, effectively. That's what it is. It's a court proceeding that is sometimes necessary to administer somebody's estate. Not always, but it's the process of your estate going through court and the process being supervised by a judge.
Okay, well, all right. That sounds simple, but do all your assets pass through probate?
No, not at all. So I like to say there's three paths, but effectively assets that go through a probate administration have to go through probate because they don't pass some other way. So other ways that your assets may pass are if you own something joint with another person with the right of survivorship. So you may own a property, or you may own a bank account, and it may say John and Jane, joint tenants with right of survivorship. Or on a property, it may say, John and Jane, husband and wife. Those assets pass automatically to the surviving spouse, assuming they survive. Other things may have a beneficiary designation on them, such as it's very common to see POD or TOD, that means payable on death and transfer on death, or ITF, in trust for, same thing, effectively all three of them. You see those on financial accounts, usually bank accounts or brokerage accounts. On a life insurance policy or a retirement account, you'll just typically see a beneficiary designation. Effectively, that's all the same. Those things goes directly to the person named on there. Doesn't have to go through probate. Probate is like a last resort. When something doesn't pass some other way, then you have to go through the court system to implement the rules under the state of Florida or whatever state that you live in to pass the assets. Also, things that are titled in a trust, whatever kind of trust it is, whether it's revocable, irrevocable, doesn't matter. If it's titled in the trust, that passes according to the terms of that document, the trust document, and also does not have to go through probate.
Wow, I just learned so much. My goodness. So I have a question. Does estates have to be of a certain value to trigger probate?
Nope, could be $1. So value has nothing to do with anything other than there's two different types of probates, and that will dictate that. But effectively, if you have an asset and it doesn't pass one of those other ways that I just described, the only way to get to it is through the probate process. So there could be $1 in a bank account, and if there's no beneficiary and no joint owner, it has to go through the probate process in order to get it. So a lot of times people have these small accounts, $500, $1,000, even a little bit more than that. And effectively it all gets lost because it's not even worth going through the probate process.
Wow, that's good to know. So that triggers a thought in my mind. Are you required to always have a lawyer to go through probate?
For a normal, regular probate, which is called a formal administration, yes. unless you're the only beneficiary, which doesn't happen all that often. Usually there's at least, two or more. So two or more beneficiaries for a formal administration, you're required per the rules to have a lawyer. But even if you were the only beneficiary in a regular formal administration, it's so complicated. I don't think anybody would have a clue how to get through the process without a lawyer. It's really just too much. Then there's a small estate, which we call a summary administration. You're not required to have a lawyer for that. Maybe about half of them are done without lawyers. It's still not a simple process, but much easier than a full-blown formal administration. In Florida, there's a lot of paperwork to file, and the process is kind of complex. So it is possible to do it without a lawyer. And I usually explain the process to people who call and say, you can do this on your own without a lawyer. But it's certainly much easier and much quicker to use a lawyer, even for those small ones. And then there's a third one called a disposition of tangible property without administration. That's a super, super small one. And that is designed to be done without lawyers. So you'll never see a lawyer doing that. It's always people on their own. And it's really a very different process.
Okay, so of course, I'm going to ask you the $1 million question. What does it typically cost for probate?
Depends. Depends on a lot of factors. For one, it depends on the lawyer that you use. Lawyers charge different things. For a formal administration, which is your typical regular administration, I'd say probably the most common is that lawyers either charge their hourly rate or they charge the statutory rate, which is basically 3% of the value of the estate assets. That's very common. Hourly rates, can range anywhere from $250 to $600 an hour, probably on an average. $250 is probably low, probably about $350 to $450 is probably a normal hourly rate for a lawyer. Usually, our firm, we don't do formal administrations. Our minimum fee is $5,000 plus the costs. The costs usually run about $700, somewhere in that range. So you can see that it's expensive to go through a probate administration. It's a lot of work from soup to nuts. And those are for simple estates. So when you have a very complex estate, if there's any sort of something being contested, litigation, an estate tax return, any sort of complications, if you have to prove a will or anything that's out of the ordinary, it can certainly increase the costs a lot. And even for small estates with the summary administrations, those can be a tremendous amount of work as well, even for a small estate. So those can be several $1,000s as well. So, there's a cost to going through a probate administration, and it's very time consuming.
Oh gosh. So that leads me to think, does having a will avoid probate?
Not at all. All it does is control the process once you're there. It simply directs who's going to get what, who's going to be in charge of administering your estate, which we call the personal representative. But the will does not cause a probate, and it doesn't keep you out of a probate. It just controls the process once you're there.
Wow. So I'm going to add to that. So then why do people do wills instead of maybe a trust?
Well, you should do both. So
Okay.
you typically shouldn't do a trust without a will, but people do wills for all sorts of reasons. For one, they just don't know any better. Either they do them on their own and they don't understand what it is, or their lawyer didn't advise them properly, or they just don't feel they need a trust, or they can't afford, to do significant's a bad word. They can't afford to do anything other than the bare minimum. A will is one of the most common documents that people know about. So it's very common for people to say, oh, I need a will. I need to do a will. And there's a lot of lawyers out there that are kind of like jack of all trades, and they dabble in a lot of different things, and they'll do simple wills for people, but they're not going to get into it's not even always super complex, but they're not going to step it up to doing those trusts because they don't know how to do them. So they'll do a simple will for somebody. And it's not bad to have a will. It's certainly a great idea. It's certainly better than nothing. And if you're trying to appoint somebody that otherwise wouldn't have preference to be appointed as a personal representative, or if you want to dispose of your assets in a way other than the default rules under Florida law, then absolutely have a will. A trust is better. But if you're only going to have one, well, I shouldn't say that because you could do a trust without a will. But if having a will is certainly better than not having a will.
Okay, that's the $1 million answer for sure. Where does probate take place, Sam?
So typically in the state where you're a resident, so wherever your principal residence is, that's where the probate should happen. And then it's usually within the county of where you live. Sometimes it's not so easy to determine that. Sometimes people don't have a principal place of residence, or they may have been absent from that county. They might have been in assisted living or something like that. Sometimes they have multiple homes where they spend equal time at, or sometimes what's very common in Florida with the snowbirds, they may actually live, let's say in New Jersey, but they die owning a property in Florida. So probate could be in your principal place of residence. It could be where you own property. It could even be where a creditor is located if they're the ones initiating the probate. But sometimes this gets problematic depending on the circumstances. We've had some just weird issues, arise, where can you do the probate?
Okay, so with that being said, let's say your dad lived in Florida, but he owns property in North Carolina. What happens?
So you always have to do a probate administration wherever real estate is located. So if you have a property in every single state in Florida, in every single state in the United States, when you die, you're going to have 50 probates. Sometimes, let's say you die in New Jersey and you had no probate there. There was no need for a probate there, but you had a property in Florida. Then maybe you can just do a probate administration in Florida. Sometimes you end up having two, and the second one is called an ancillary estate. So you have the primary or domiciliary estate, and then you have the ancillary estate, or sometimes you just end up having the one, even though you don't reside there, but you have property there. So typically what we want to do under most circumstances, when you own property, you want to put it into a trust. But if you have property outside of the state, you definitely want to put them all into your trust so that you don't have all these multiple probate administrations, because obviously it gets very expensive and time consuming because you have to find lawyers in other states, to help. Occasionally you'll find a state where they have a more relaxed process. But it depends on the particular jurisdiction. Ooh, sorry, I thought I had that on mute.
Okay, so all right, so I get that wow. Okay, so that was a lot to digest. So I'm going to give you a scenario here. If my mom died and she named my sister as a beneficiary on one of the accounts, but her will leaves everything equally to her 3 children, are we all entitled to that money?
No, doesn't matter what the will says. Going back to one of the other questions that you asked earlier, what goes through probate? Only assets that pass through the probate administration are controlled by the will. So anything that passes outside of the probate, it doesn't matter what the will says. It has no effect on those assets. So people do that. It's very common where they'll have joint accounts with one child for convenience purposes, and they don't realize the significance of it. So when they die, that account passes automatically to the surviving child. It's theirs legally 100%. They don't have to share with anybody. And sometimes, even if they were intending to share, to informally honor mom or dad's wishes, something could happen to them. They could become incapacitated. They could die. They could get divorced. They could get sued. before sharing the funds. And then it's out of their control. It's their money legally. So it's not the best idea to have joint accounts with one child unless you intend for that child to get 100%. Not a good idea to name one person as a beneficiary with the informal idea that they will share, with a bunch of people. Occasionally that's an okay plan under some circumstances. Sometimes, when there's 50 beneficiaries and they're all problems, sometimes you take the risk and that's the choice you make. But in general, that's not a good structure to put in place.
Wow. Okay. Well, that's something to definitely keep in mind. Is it true that the government taxes assets that pass through probate?
Oh, I hear it all the time. People say, oh, well, if I don't have a will, the government's going to take everything, or I'm going to pay taxes. And that's just not true. There's costs involved with going through probate. There's legal fees, there's court fees, but there's no extra taxes. And the government doesn't take anything unless you literally have no beneficiaries. So that is technically possible if you had no heirs at all, no children, no spouse, no siblings, no nieces, no nephews, no cousins, no aunts, no uncles, nobody. You literally had nobody. If you didn't have a will, then your estate would escheat to the state of Florida and it goes into the unclaimed funds, and it allegedly supports our educational system.
That is funny. Okay. We got to keep searching that. Is probate the same in all 50 states? I think you touched on this a little bit, but
Yeah, not at all. It's so different. And I don't know what all the rules are in all the states. Every now and then we're exposed to it because we'll have an ancillary administration someplace else. But it's very, very different in most states. Florida is probably one of the most extensive states for our probates. Pennsylvania, I believe, is pretty simple. It's not common at all to have a trust in Pennsylvania because their process is so simple. We recently were able to do a procedure in Texas where there was a property, and we were able to record our probate documents there, and that passed title to property. So we didn't have to open up an ancillary administration. So that was kind of neat. But very, very different in every state. So you have to, you really have to have a lawyer, a qualified attorney in each state, wherever you're going to do a probate administration.
okay. And I think we touched on this a little bit, but what happens if there is no will at all?
It passes under the laws of the state wherever the probate administration would be. So we call that intestate. So it means you died intestate. And then most of the states are probably similar in how things flow. So it may go 100% to your spouse. Sometimes it's split between a spouse and children if you have children outside of that marriage. Usually goes down the line, to grandkids if you have any deceased children. And then it would go on, to more distant relatives, depending who survives you. And a lot of people don't realize, because of the going down the line, to your descendants, a lot of people don't realize, oh, well, so-and-so, predeceased her, so now it should be shared among the living children. Well, no, it's not how it works. So that share goes down the line. So sometimes you end up with a whole list of beneficiaries in an estate. And this is probably most common when, for one, they don't probate right away, because there's no time requirement to probate an estate. So I see it all the time where years go by and somebody's estate is not probated. So then the assets are out there. Well, during that time, people are going to die. And then you have their children. And the more you get removed from the deceased, the less likely it is that the people down below, that you have a relationship with them, that you know where they are, that they're all available. We see oftentimes people are estranged from their family. We have a situation right now. One of the beneficiaries is homeless. Well, we can't find them. And even if my client kind of has an idea of what geographic area they live at, I mean, they literally live like under a bridge, we can't show up to this person with a notary and a witness and try to get them to sign, paperwork. That's just not practical. So I had an estate recently. It was a very small estate. There were 13 beneficiaries, probably all in excess of 85 years old.
Oh my gosh.
All of them. Getting them all to sign documents was extremely challenging. And then, of course, before we reached the end, somebody died. And then it goes into their estate. So without getting too technical, you don't go down the line unless that person died before the decedent. So if that person survived and then died, you have an estate for that beneficiary, and then it goes down to their children. So it can get really complicated. And you see this mostly with very tiny estates, because if it was a large estate, somebody would have come forward and administered the estate. But you oftentimes see it with a piece of real estate that's not too valuable. So it's like a double whammy. Not only do you have this super complicated estate, you have a very little amount of money at stake. So it's really worthwhile for people to probate estates promptly to avoid these problems.
Wow. And it's so amazing. We do have a question in the chat that just falls right in line here. Who pays expenses on the property while it's in probate, like taxes, insurance, mortgage, HOA fees?
It's a great question. And so there's a legal answer and then there's a practical answer. So the estate is responsible for those expenses. Usually, if there was a will and the property was specifically devised to a beneficiary, then technically that beneficiary may be responsible for those expenses. But practically, it takes a while to get access to money, or sometimes there is no liquidity. Let's say there's just real estate involved or there's stocks, So it can definitely take sometimes months before you have access to any money to pay these expenses. And if you don't pay the mortgage, at a minimum, you're going to incur fees. At worst, it's going to go into a foreclosure. The HOAs don't wait for their money. They initiate proceedings right away. You got to pay FP&L or they're going to cut off the electricity. So it's definitely an issue. Now, if you have a generous person that's willing to advance the cost of these things, usually we're looking at the personal representative. That's fine. As long as they're willing to do that, that's the best solution. They can advance the money. They're entitled to reimbursement, once they have access to the funds and the estate is open. Sometimes it's not that easy. Sometimes people don't have the money, or they're just simply not willing to part with it. Sometimes you have a personal representative who is not a beneficiary. They're just there doing a favor to the decedent, and they're administering this estate. They are entitled to take a fee, but they don't want to come out of pocket to advance and pay costs of an estate that they're not a beneficiary of. So it's another great reason to avoid probate, because if you were in a trust, you have almost immediate access, to the funds. You don't have to wait for the court to open up a case and assign a case number, assign it to the judge. You don't have to prepare pleadings, submit them to the court, wait for the judge to sign orders, submit those orders to the financial institution, wait for them to close the account and put it into an estate account. That all takes a significant amount of time while expenses are just racking up.
Wow. Boy, good to know. That's very good to know. On a different note, what happens if your original will can't be located?
So that's definitely a problem. The rule in Florida is that if the original will cannot be found, it's presumed that it was revoked. So that's the presumption. Now you can overcome the presumption, perhaps. If nobody contests it, then most likely the court will admit the will and you'll overcome the presumption and you'll move along, but there's a whole procedure that you have to go to. So that increase the time and the costs involved in the administration. But you are required to put on notice any heir. So any person that would have received something from this estate had that will not been admitted. So that's great, right? So you tell somebody, hey, you would have been a beneficiary, but we're trying to get this will admitted, and then you're not going to receive anything, or you're going to receive less than what you would have received. So, you know, you're almost like sending them a card saying, would you like to contest this estate?
Oh my gosh.
So that's always challenging. And hopefully you have a copy of the will at least. So technically you can try to prove up a will even without a copy. That is really, 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 really hard. I have never had to do that in my entire career. That's hard. But even with the copy, you know, you have to overcome the presumption that they didn't intend to revoke it, because you can have a gazillion copies floating around out there, but that doesn't mean you didn't revoke the original will. So in our world, an original document is still really, really important, where in everything else you do in life, you know, everybody docu-signs everything and copies are fine. But that original will is still very relevant in probate.
Do you have a place where you keep the wills? Is there a depository or something like that?
No, that's another challenge, because there is no place to keep them. The most usual places are either with the attorney, in a safe deposit box, in a file cabinet at home. Safe deposit boxes are challenging because they're difficult to get into. Plus, people may not even know you have one. They may not know where it is. You may lose the key, and then you have to drill it, which is not the worst thing because at least you know where it is. But a lot of times, family members will find a weird looking key. So they know it's a safe deposit box, but they don't know where the box is. So I've had people literally go around bank to bank to bank. Is this your key? Is this your key? Is this your key? So in our office, we retain all of our clients' original wills and trusts. We don't even give them an option anymore. We just retain them. Unless if they insist on having them, of course they can have them. But our default policy is we retain them. That way we know where they are. They're not going to lose them. They're not going to write on them. They're not going to burn them. They're not going to get them wet. And when somebody comes looking for it, we know exactly where it is.
Awesome. We have another really good question here. What happens to a business owner in the case of probate? And there's a second part. Does businesses have to be listed in a trust or business bank account?
So I'll do that second part first. So whenever we do trust, we always transfer businesses into the trust. It's super simple. We do it by an assignment, whether it be a corporation or an LLC. Sole proprietorship would be different, very different, more challenging because there's no entity there. And that way the successor trustee named in the trust can continue with the business if the person is incapacitated or upon their death. Nice and easy peasy. They can continue, operating the business, continue to make payroll, continue to sign contracts and keep things going. If it's not in the trust and it's just in the person's name and they die, or they become incapacitated, well, then who has authority to keep the business going? Then it's going to depend. There may be somebody else named on the business bank account. So maybe somebody can continue to sign checks, or maybe somebody within the business has some sort of authority. Ultimately, the ownership of that business will need to go through a probate administration to pass on to the beneficiaries. But oftentimes they come to a screeching halt because nobody has any authority. The business owner never gave any thought to what happens if I drop dead tomorrow, or I get hit by a bus, or I have a heart attack and I'm incapacitated. Is anybody else on the account? Does anybody else have authority? And when employees see that they're not going to get a paycheck this week, and a lot of people are living, paycheck to paycheck, they're jumping ship. So they're gone. They can't wait, 3 months for somebody to get appointed as a personal representative and hopefully have access to money. Or think of like a dental office, especially like orthodontist, right? So kids are coming in constantly to have adjustments and this, and they've paid in advance, right? It's really common that they've paid in advance. Now the business is what? Where's the dentist? Where did you want the dentist? You're going to honor my payments? What, I can't come back in here for 3 months? And guess what? This requires a special license. Well, who's going to continue this going? Who has the authority to do this? So it can get very messy, very, very, very fast. Businesses often lose all of their value or a significant portion of it immediately. So this is always a conversation I have with clients, what do you have in place? And usually they've never even thought about these issues. So at least we get the wheels turning, and we get documents like durable powers of attorney, and we transfer assets into trust so that they have some sort of, very seamless continuity of the business.
Wow, I learned so many things. My goodness. So I'm gonna piggyback off of that before we tie this all up in a bow. So I am on my husband's business account in the state of Florida. I am 50% owner. So if something happens to my husband, I should be able to carry on my business, or no?
So there's a difference between ownership and being like an officer, director, something like that, or just being a signator on an account. You can have an employee be a signator on an account, and that just means that they can sign checks or make withdrawals. The only place you're going to see ownership, true ownership, is on a stock certificate or in an operating agreement. You may see the ownership listed on a tax return, but you're not going to see it on Sunbiz or anything like that, because that doesn't really show ownership. So ownership is what you own when you die, and that's what has to pass through probate if you own something that doesn't pass automatically. Being able to access a bank account is a little different, and if it's like a service business, like you or I have, if your spouse is listed on the account, well, they can go and just take all the money out, and that's really all you have if you don't have any hard assets and you don't have something that's going to continue after you're gone. So sometimes just having that suffices, because there's nothing to really pass on to anybody. The business is going to fold when the owner dies. So it really depends on the type of business, but the ownership. So like if you have a corporation, an S Corp, a C Corp, or if you have an LLC, you're going to transfer that ownership into your trust, as well as having somebody perhaps on the account, so that they can get the money out. If you were incapacitated and somebody's on the account, then they might be able to at least continue operation of the business. But oftentimes, you're going to want to arrange for the business to be sold as soon as possible, if it's something that can be sold. So a conversation I have with my clients is, who's your competitor?
Mm.
Who might want to buy your business if something happens to you? Does your spouse know anything about your business? Do they know who your competitors are? Make a list.
Mhm.
Hey, call ABC Liquor, or whatever the competitor is, see if they want to buy it. The faster you dispose of the business, the more valuable it will be.
Wow, that was really good information, even for me. I'm glad I'm here. I have another question, and then we're going to wrap it up. What happens when the trust attorney is gone, dead, or bankrupt?
Good question. It happens all the time because these documents live on for so long. So I get a ton of clients because the client previously did documents with somebody else, and they either can't find them, or they retired, or they died, and now they need to redo their documents. So I'll tell you from my perspective what we do. So we keep a lot of original documents here. Per the Florida bar rules, we're supposed to name an inventory attorney. All lawyers are supposed to name an inventory attorney. And this person is supposed to step in if you become incapacitated or you die. It can be any attorney, but practically, if it's somebody that is in your practice area, they can just take your cases over. So that's really important. So I have an inventory attorney named for me, who's right here in my office, who does what I do. So that's like a super easy transition. If they don't have your original documents, then it doesn't really matter. If your lawyer dies or something happens, then you just go to another lawyer. It may be more costly to get changes made because, when our clients come back to us, we have their documents in our system, and it's really easy to just, modify them. But if they're holding on to your original documents, then the lawyer should have some sort of plan in place whether they have staff, whether they have their inventory named, but they should have some sort of plan. It's common. I see lawyers go out of business with whatever happens, they die or whatever, and they don't return their original documents, which I am like, it blows my mind, because I know my staff, if I were to die, aside from my inventory attorney, would contact every single client that we had and return their original will or trust.
Well, I look forward to hearing from you and seeing you next month. Have a happy and healthy new year.
Thanks
Thank you.
guys. Take care. Bye-bye.
Bye all.